So indeed, I'm going to talk about the AML package, basically, that was published in last July by the European Commission. So it's going to be more of a theoretical speech. I'm sorry about that, but you'll see that there's still interesting things to note about that new AML package. So basically, what I'm going to talk today about is a bit of background, then the AML regulation proposal. Of course, all of these are proposal. The sixth AML directive, the proposal for regulation for an AML authority at EU level, and the revision of the wire transfer regulation and next steps. So a little bit of background. I always like to start the presentation with giving a bit of figures. I think the previous speaker already gave you kind of some flavor of the numbers of illicit flows, but still interesting to know that according to the IMF, already 25 years ago, 2 to 5% of the global GDP would be black money, illegal economy. The UNODC, the United Nations Office Against Drugs and Crime, estimated in 2009 that 3.6% of the global GDP would be illicit proceeds. In 2011, it estimated that only 0.2% of those illicit proceeds would be actually seized globally, which means that 99.8% of the illicit flows will still be in the hands of the criminals. So that shows you that whatever we're putting in place is not working yet efficiently, and that we have to do more efforts to fight illicit flows by money laundering prevention and other systems alike. At EU level, the EU estimated in 2013 that around 330 billion euros would be laundered each year in the EU, but that might be an underestimation because the finance minister of Germany made an evaluation in 2016 and estimated that just for Germany, there would be up to 100 billion euros laundered every year. So that gives you a bit of the magnitude of those illicit flows within the EU as well. And Europol published in 2016 a report saying that only 1.1% of those criminal proceeds would be eventually confiscated. So again, that shows you how and why fighting illicit flows is such at high stake at EU level, where we're about to adopt our sixth AML directive, which shows you how much the EU legislator is focusing on that topic as well. As you know, there's a dual approach to fighting money laundering and terrorism financing. There's a prevention and there's this enforcement. The prevention is the administrative and regulatory legislation and regulations, which puts responsibility on the private sector, meaning identified obliged entities, those who are considered to be at risk for money laundering and terrorism financing purposes, to put in place an internal framework that is designed to prevent, detect, and report money laundering and terrorism financing suspicions. If they fail to do so, if they fail to take appropriate positive obligations and implement a sound and risk-based framework, they might be subject to administrative sanctions. That's what we're going to focus on today. That's what the AML package is about. There's obviously the other side of the fight against money laundering, which is enforcement. Enforcement is putting responsibility on the public authorities to investigate and prosecute criminals that have engaged in money laundering. There's a directive that has been adopted on that end as well by the European Union, 2018 directive, which had to be implemented by late 2020. I'm not going to talk about it today, but it is interesting to know that this is the first directive at EU level that focuses on a single criminal conduct. Again, that shows how money laundering is seen as an important stake to fight at EU level. Last but not least, on that little background and introduction, just to show you the interplay of the prevention and enforcement regimes. As you see, there's the obliged entity on the first part. The obliged entity might be a bank, might be a lawyer, might be an insurance company that has to know their customers, what we call KYC, so identify and verify the identity of their customers, understand their characteristics, to be able to make an assessment of the customer from a risk profile perspective, determine whether the customer is high risk, standard risk, or low risk, and then conduct appropriate due diligence on that customer to be sure that the transactions, the activities they carry out are legitimate, are not suspicious. And if they have suspicions on those customers, they have to carry out an investigation. And if there are suspicions of money laundering or terrorism financing, they have to report the information to the FIU, the Financial Intelligence Unit, which itself will carry out another investigation to see whether there's really evidence or better suspicions of money laundering or terrorism financing, in which case the case will be referred to the prosecution office for criminal investigation, and in the end, referred to the criminal court for prosecution. So that's really the interrelation between the two aspects of the fight. Again, I'm going to focus today on the prevention aspect and on the importance and consequences that the AML package will have on obliged entities. So at EU level, I told you that we're going to a 6th AML directive. Just for a bit of background, remember that most of the legislation on the prevention of money laundering and terrorism financing, which I will call AML, anti-money laundering for convenience, come from the FATF, the Financial Task Force, which is at international level and exists since 1990, and creates and publishes and updates 40 recommendations. As the European Commission is a member of the FATF, the European Commission implements those recommendations into directives. So for the first, second, third, and fourth directives, they really stemmed from the FATF recommendations. But interestingly, since 2016, the EU has decided to work alone to take its own initiatives. And so the 5th and proposed 6th directives are initiatives of the EU alone. This shows how the EU has decided to even go beyond what the FATF is setting as standards, but the EU wants to go further to further protect its financial system. So how did we come to that proposal, to that EU AML package of 2021? The background is, the first one is the number I gave you, that Europol estimated that around 1% of EU annual GDP is involved in suspect financial activity. That's one, that's a given. The second thing is, you might remember that there has been a huge banking scandal in 2018-19 with the identification of a bank who had failed to properly screen over 200 billion euros in non-resident flows, most of which were considered as suspicious transactions upon review, which did pass through the EU financial system unnoticed. That's the Danske Bank scandal, which you might have heard of, and which really highlighted that there's an issue in terms of harmonization of AML standards at EU level. Interestingly enough, if you look at the recent news, there has been a woman charged within the scope of that scandal for actually laundering 4.5 billion euros through Danske Bank and that big scandal. So these are the two triggers that led the EU to start review the actual and current framework. And in July 2019, the EU Commission adopted a communication on better implementation of the AML framework as currently existing, and published 4 reports on different aspects of AML policy. The findings of the Commission was that there were delays in implementation and divergence in national rules. That's not new. I mean, we know that every time there's a directive, directive are generally, at least in that scope, of minimal harmonization. So there's different levels of harmonization between countries. There's those countries who just implement the minimal standards adopted by the directive. Some do some gold plating, go further, and some have some gaps in the implementation and actually do not perfectly respect the requirements of the directive. So that's the first thing. Second thing, delays. If you look at another example, the whistleblowing protection directive, which had to be transposed for larger companies on 17 December 2021. The EU Commission, I think, issued a formal letter of infringement to 23 member states. So this is another issue. So basically, the Commission observed that there had been a fragmented approach across the EU towards the implementation of anti-money laundering directives and legislation, and that there was a lack of central coordination of those rules. There's no central body at EU level. There's hindered cooperation between supervisors and FIUs. Therefore, the EU concluded that there was a necessity for a further reform. What the EU then did is publish an action plan in May 2020 for a comprehensive union policy on AML. The reform that was contemplated was based on 6 pillars, while ensuring effective implementation of the existing framework, establishing an EU single rulebook on AML, CFT, bringing about EU-level AML CFT supervision, establishing your support and cooperation mechanisms for FIUs, enforcing EU-level criminal provisions and information exchange, and strengthening the international dimension of the EU AML CFT framework. The second, third, and fourth bullet points, which are, you can see, are in a dark gray blue, are those who were the subject of focus of the EU and which were translated into that EU AML package. And that's what I'm going to talk about today. Just a side comment, you will see that there's around 55 or 60 slides in this presentation. I'm not going to talk about them, each of them in length. I always prefer for you to have a longer, bigger support if you want to have more information, but I might skip some of these slides depending on the time that I have. I think I have 30 minutes left, so we're good to go. So those legislative proposals, which were published on 20 July 2021, consist in that EU single rule book. So basically, there are 4 proposals, 3 regulations, and 1 directive. So the first thing is an AML regulation. Well, I'd like to say that it was about time, because we're in a regulatory environment and we were still working with directives. But if you look at many other subjects like market abuse and others, we are already working with regulations in the finance sector at EU legislative level. So I think it was about time to take an AML regulation for the purpose of harmonizing legislation, setting standards that are consistent everywhere. So basically, that AML regulation translates the most important requirements and topics of the current directive framework into the regulation, with some adaptations, and I will talk about them in a minute. Then, in addition to the regulation, which will be now the basis, the core legislation for AML purposes, you have a 6th AML directive proposal, which will be adding some points that will not be harmonized to such an extent as those in the regulation. So that's where you will still have a bit of gold plating or differences in implementation. Then, and I think that's the most important, that's really the core of this AML pack in terms of novelty, is the creation of AMLA, the AML Authority at EU level. It will be the first authority that will be dedicated to a single subject like that. So it will be EU authority body just working on prevention of money laundering and terrorism financing. And I'll be addressing what is contemplated for that for AMLA in the slides later on. So that's really a big revolution. And last but not least, there's the revision of the wire transfer regulation. Remember that the first wire transfer regulation was adopted in 2015, the same day that the fifth AML directive was, the fourth, sorry, AML directive was adopted. So here it's a revision, it's an update, basically to include virtual assets transfers within the scope of that regulation. So going to the AML regulation, let's see what it will tackle. So the rationale of adopting the regulation, as I told you, is to translate and transfer the obligations of private entities that are currently emanating from the AML directives to a regulation. As I told you, the European Commission has observed that there's difficulties in adapting and adopting the fifth AML standards into all the different legal systems. And therefore, the idea is to try to eliminate those divergences by adopting a single standardized legislation on AML by means of a regulation. Because today we can see that there's some forum shopping as well, because there's some arbitrage that is done both by private entities doing business in different member states, but also by customers to decide whether they're gonna try to go in that jurisdiction or the other, because they know that maybe with regard to CDD, customer due diligence, or with regard to high-risk third countries, they are more or less exigent and apply more or less stringent requirements. So the idea is really to get rid of all of that and to really have a harmonized system and thresholds, and to prevent private entities from taking advantage of the fragmentation of the implementation of EU AML legislation to protect the internal market. So the scope of the AMLR includes the most important topics. I mean, in terms of matter and scope, including obliged entities, what are the internal policies and controls and procedures have to be implemented, information on customer due diligence, third country policies, PEPs, reliance and outsourcing, UBOs, reporting obligations, data protections, and measures to mitigate risk of bearer instruments. I will not address them all today. I will just give you a few information on the most interesting topics and evolutions that go beyond just transferring the current framework to regulation. The regulation goes a bit further on certain topics. For instance, in terms of obliged entities, the regulation will expand the scope of crypto asset service providers, because you know that today are only covered by the directive those providers that do fiat to crypto or crypto to fiat exchanges and wallet custody providers, but no, not those providers who do crypto to crypto exchanges. Now they will be included in the scope of the obliged entities, because obviously this is a gap. There's other obliged entities that are being added to the scope of obliged entities, as you can see here, in terms of crowdfunding, creditors for mortgage and consumer credits, and investor residence schemes. In terms of internal policies, controls, and procedures, there's not much change from the existing framework, just clarifications that are given by the regulations in terms of requirements that must be applied for risk assessments that obliged entities have to carry out. risk assessment, the overall risk assessment, the business-wide risk assessments to assess their own exposure to money laundering and terrorism financing, but also towards customers. There is also clarification of the role and the task of the money laundering responsible officer, the compliance officer that's responsible for AML internally, and on how to create awareness of management staff in terms of AML. And there's also clarifications of requirements applicable to groups, because you know that where a group has different entities within different member states, there must be a group approach that must be implemented, and the regulation tries to give more insight on how to do this. In terms of customer due diligence, again, clarification on the information that must be obtained on customer for identification and verification purposes. More interestingly, the Commission does clarify the requirements for obliged entities to use electronic identification and verification, because you know that's something that's quite high on the agenda today, to facilitate customer onboarding and to secure the information collected on the customer. It's better to have an electronic identification than just to receive a scan of the physical ID of the customer. But obviously there are issues related to electronic identification and verification, and the regulation, sorry, already contemplates the possibility to do that electronic identification and verification by means of the European digital identity. As you might know, it's a proposal of directive that has been published recently, being discussed, and which would really have a huge potential to speed up the cumbersome CDD process. So still process to be done in that area, but interesting evolution possible. Last point is that AMLA, which we will talk about after, will be empowered to produce regulatory technical standards and provide requirements on CDD, specific requirements that will have to be implemented for simplified customer due diligence in line with the upcoming European revised supranational risk assessment. That's really a point that's interesting and important to note, because AMLA will really have that power and competence to create, to publish technical standards, which will have to be followed by national supervisors and obliged entities across the EU. Another interesting development is the discussion of third countries, and among others, high-risk third countries. As you know, there has been quite some evolution on the list of countries that are considered to be high risk by the European Commission, with growing divergence between the list from the FATF and the EU list. Here, the regulation suggests to create two categories, two lists for countries of higher risk, such as the FATF is doing. What we call the blacklist, the list of the FATF of countries subject to a call for action. And at EU level, that list will subject those countries to full EDD, so enhanced due diligence. So those countries and those customers which have a relationship with those blacklisted countries will have to be subjected to full enhanced due diligence in compliance with the regulation. Then you have what I like to call the gray list, those countries that are listed by the FATF as being subject to increased monitoring. In that situation, obliged entities will have to apply a country-specific enhanced due diligence. So it will not be the fullest enhanced due diligence requirements, but for each of these gray list countries, there will be country-specific enhanced measures for due diligence purposes. So we do have a separation division between two lists, which does not exist today. Lastly, the Commission will be empowered to identify third countries which are not listed by the FATF, but that the EU considers are posing a specific threat to the EU internal market, and then place them in the either list. That's what exists today. I mean, today you have the FATF list, and then you have the EU list that goes beyond what the FATF is actually listing as problematic countries. So this is a formalization of what's happening today, but with two lists to have more harmony with the FATF methodology. In terms of UBOs, again, the regulation gives more clarifications and provides detailed and harmonized rules for UBO identification, including, and that's interesting, a possibility for the EU to adopt Commission implementing acts on how to identify or to adopt a consistent identification, among others, on express trusts and similar legal arrangements. There will be new disclosure requirements for nominee shareholders and nominee directors. And most importantly, and I think that's a real evolution, not to say revolution, is that legal entities which are incorporated outside the EU, so third countries, which today are not required, obviously, to be registered in EU national, in member states UBO registers, they will be now required to register their UBOs when they enter into a business relationship with the EU obliged entity, or when they acquire real estate within the EU. So third country legal entities will have to register themselves in member state official UBO register in certain circumstances. That's interesting because, as you know, there's a difficulty today to identify the UBOs of third countries, although it's said that there's almost 80 countries worldwide which have, to a certain extent, UBO register. Last point on the regulation is there will be an upper limit of 10,000 euros on accepting cash payments by traders in goods and services. So there's a typo here. This already exists in two-thirds of the member states, so there's no true revolution. And obviously, the national limits under 10,000 euros can remain. Belgium, for instance, applies a 3,000 euros limit. So that was for the AML regulation. What about now the 6th AML Directive? So the proposal the directive, if and when adopted, will repeal the 5th AML Directive. So that will be the only remaining directive on AML. Here are the different topics that are addressed in this proposal. There's again about obliged entities, because the directive will allow countries to extend the list of their obliged entities beyond what is in scope of the AML regulation. The directive also gives further insight on risk assessments, UBO registers, FIUs, AML supervision, administrative measures, sanctions, and cooperation. I'm not going to talk in length about the directive because it does not provide as much as evolution of a revolution as the regulation or the AMLA. What is interesting to note basically is that there will be an enhanced supervisory coordination, cooperation, and efficiency with contact points between certain service providers, some licensing or registration obligation that did not exist today, more frequent risk assessments at EU level from the Commission to determine how the member states are doing with regards to the implementation of the AML Directive, and further integration of registers and mechanisms of beneficial ownership, but also on bank accounts and real estate. In terms of focus on supervision, the directive insists on AML supervision, including the creation of supervisory colleges. It gives a bit more information on measures and sanctions. So the current measures and sanctions applicable will not evolve drastically. The upper limits of administrative sanctions, which today is of up to 10% of the annual turnover of the last year, is not changed. What the directive gives as new clarification or subtleties is more about the different measures that can be taken by national authorities for less important breaches. So more in terms of penalties, of replacement of boards, etc. So it's more about measures for less important infringements than on huge violations. Also, it creates public oversight over self-regulatory bodies. So if you're taking non-financial obliged entities, let's take lawyers, as I'm a lawyer, you have the lawyer chairman, let's say, of the bar, which we call bâtonnier in French, who is the self-regulatory body that has to control all the lawyers from the bar. So basically, under the 6th AML Directive, there will be an obligation for those SRBs, self-regulatory bodies, to be overseen by a public authority, to be sure that they're applying all the required standards from an AML perspective, because it's often said that self-regulatory bodies have less maturity on AML than the financial sector, which has been an obliged entity since the creation of the system. I think I have a bit more than 10 minutes, so we're gonna focus now and discuss more in depth of AMLA. So AMLA is really the revolution today, as I told you. It's gonna be one single AML authority at EU level, which will have the direct supervision of some entities, indirect supervision of others, and who will coordinate also mechanisms for FIUs. So as I told you already, AMLA will try to centralize everything and to create and integrate the system of AML CFT supervision across the EU based on common supervisory methodology and convergence of high supervisory standards. As I told you, AMLA will be responsible for producing, publishing technical standards that the EU member states and obliged entities will have to follow. Second, AMLA will have the direct supervision of the riskiest cross-border financial institutions. So a bit like if you would compare, like the ECB has direct supervision over the systemic banks. Here, AMLA will have direct supervision as an AML authority on the riskiest cross-border financial institutions. We will discuss a bit further in the presentation what that means and how those riskiest cross-border institutions will be selected, and that's what we call the selected entities. Okay, it's based on the number of member states they're in and the fact that they're classified within each or a lot of member states as very risky, high risk, etc. So direct supervision on these institutions, on the selected institutions. But in addition to that, AMLA will also have the right to take over the supervision of any financial institution in case of an emergency and if the national supervisor is inefficient. So basically, let's think that of the situation that there's a financial institution, that there's a bank where there are some failures, important failures that have been observed, and which creates a large exposure and risk. And well, AMLA as the national bank of that member state to take all the measures necessary for the obliged entity to remedy to its situation. And AMLA observes that the national bank of that member state, which is the national supervisors for AML purposes, is not taking adequate steps or not ensuring adequate follow-up. Well, AMLA will have the right to go to European Commission and ask for taking over on the supervision of the failing obliged entity because the national supervisor is not doing its work adequately. So that's very interesting because it gives a huge power on the EU authority. Also, AMLA will have the indirect supervision of the other financial sector obliged entities, those non-selected entities, and also on non-financial obliged entities via oversight and coordination of their supervisory bodies. And last but not least, as I said, coordination and support mechanism for FIUs. I will discuss those a bit more in length in a few minutes. So how will AMLA be organized? So currently, the idea is that AMLA will have total staff of around 250 members when operating at full cruise. And that I think it was around, let me see, that the budget estimated will be of around 45.6 million euros per year for the functioning of AMLA, 3/4 of which will be paid by fees, will be financed by fees paid by obliged entities. So basically the functioning of AMLA will be financed 3/4 by obliged entities within member states. It will have 2 collegial governing bodies, an executive board of 5 independent full-time members and chair, and a general board composed of representatives of member states, including heads of national authorities and FIUs. So the general board will be composed in 2 ways, depending on the tasks that are assigned to it. If the general board is working on AML supervision, well, it will be a supervisory composition with the heads of the public authorities responsible at national level. If they're working on the FIU competences, well, it will be an FIU composition with heads of member state FIUs. Note that actually when AMLA will be working properly, it will take over the infrastructure of FIU.net. So AMLA will really take some responsibilities on existing infrastructures, including in terms of FIU cooperation. The executive board will be the governing body of AMLA and will take all decisions towards individual obliged entities or supervisory authorities if AMLA is carrying out direct and indirect supervisory functions, like imposing sanctions, conducting investigations, etc. Let's talk about the supervisory system, the topics that AMLA will tackle before going into more details on the specific supervision. The idea really, as I told you earlier, from the findings of the commission, and there's the lack of cooperation, of standardization, of coordination and cooperation between bodies among the EU. So the idea really is to create a cooperation in the system, whereby the system is AMLA and all supervisory authorities within the member states. Obviously, there's a duty of cooperation in good faith, and AMLA will create a supervisory methodology for that purpose to try to harmonize, create handbooks for supervision for national supervisory authorities with harmonized standards, practices, etc. AMLA will also assist in mutual assistance to create formal mechanisms for assistance and cooperation that will be coordinated at central level by AMLA, and there will be a central AML CFT database at AMLA level. They will be taking over the database which the EBA is currently maintaining, and the data will only be accessed by authorities on a need-to-know basis. Let's switch now to direct supervision. As I told you, the idea is to supervise directly the riskiest cross-border financial institutions. So what AMLA will do is basically carry out supervisory review and assessment, both at group level and at individual entity level. Because as I told you, those selected institutions will be institutions that are cross-border, so that have entities in multiple states, member states, so basically who are a group. And so AMLA will really focus on the assessment of the group at once, and also of its different entities. Then it will help develop and maintain a system to assess risk and vulnerabilities of those entities, and adopt decisions, measures, sanctions toward those directly supervised obliged entities when inspections will have revealed failures. How will those high-risk cross-border institutions, those selected entities, be selected? Well, as I told you, it will be based on different criteria, objective criteria, including the number of member states in which the organization, the group is present, and the risk classification of each entity in those countries. And this list will be reviewed periodically every 3 years. The first selection of these selected entities will be carried out by AMLA in 2025. And their supervision by AMLA will start in 2026. So there's still time ahead, but beware. Also, as I said, AMLA will be able to take over on non-selected institution where there's a failure to meet the AML CFT requirements, and that national supervisors do not take appropriate follow-up actions in that regard. In terms of sanctions, because I told you that AMLA will be competent to impose sanctions and measures directly to those directly supervised selected entities. Well, the fine will be of maximum up to 10 million euros, or again, like the current system, 10% of the annual turnover. In terms of measures, which are not sanctions per se, AMLA will also have the possibility to impose periodic penalty payments, what we call astreintes in French, to stop ongoing violations. You know, to say, well, on a daily basis, you have, if you're not complying with those requests, if you're not stopping that violation by that date, well, you will be subject to daily penalty of up to 3% of your daily turnover, and that measure can be imposed for up to 6 months on the failing entity. In terms of indirect supervision, as I told you, so AMLA will have direct supervision on entities that are the riskiest, and indirect supervision on the rest of the financial sector and on the non-financial sector via by means of the coordination of their national supervisors. So here you really see the two-phased approach. In terms of indirect supervision for the financial sector, AMLA will assess the state of supervisory convergence, coordinate and facilitate the work of the AML supervisory colleges that I was referring to, and do some peer reviews and thematic reviews. Last point that appears to be very interesting is the coordination and support that AMLA will provide to the FIUs. Basically, AMLA will help FIUs to improve their analytic capacity around illicit flows and make financial intelligence a key source for law enforcement agencies. So AMLA on one hand will create, for instance, suspicious transactions and suspicious activity reports templates that will be disseminated in all member states. So there will be an easiest communication and cooperation between member states, because all member states, all obliged entities will work with the same SAR and or STR template, so that when it has to be sent from, I don't know, France to Germany, it will be the same document that will be known from both institutions. So that will swifthen the process and ease cooperation. In addition, AMLA will provide support in joint analysis by national FIUs, which is quite interesting. Because it will actually assist the different FIUs in the joint analysis. What about AMLA implementation? So the EU Commission aims to have AMLA established by 2023, so next year already. The first 2 years will be limited to the indirect supervision through national FIUs, so really on the FIU aspect of coordination and support, not on the supervision of direct or indirect of obliged entities. But it is expected that AMLA will not be fully operational before 2026. So it will complete staffing and direct supervision over high-risk financial entities over the time. Regarding the wire transfer regulation, I see that I'm almost done with my time. So I'll just give you a couple words. If you remember the wire transfer regulation, the aim is really to have the right information communicated from a paying institution to another in terms of information on the payer and on the payee. So a name, address, and identification. Well, address is not mandatory, but at least name and bank account details on the payer, on the payee, and that must be communicated. And if the information is missing or seems to be mistaken, measures have to be taken. That's the wire transfer regulation. Well, the second wire transfer regulation, the proposal that has been published, basically expands the traceability requirement to crypto assets, which is in line with all the discussions we have today on the fraud risks and the money laundering and terrorism financing risks associated with crypto assets. Note that there have been opinions published by the European Banking Federation and the European Data Protection Supervisor recently. I'll let you read the slides, and just to conclude the discussion, where are we today in terms of adoption or of discussion on the AML pack? Well, there's the opinion of the European Data Protection Supervisor that has been published in last September, and the Economic and Social Committee in last December. Now we are at the stage of first reading discussions at council level. Then it will be sent out to Parliament. The EU is hoping for a speedy legislative process. They're actually hoping to adopt the full package this year in 2022, which would be quite a record in a way, because you may know that the average timing of adopting a proposal after its publication is around 2 years. Here, they're really intending to do it in a year and a half or so. AMLA should be operational in 2023 or 2024, and starts the work of direct supervision in 2026. The implementation deadline for the 6th AML Directive will be 3 years and not 2 years as usual. And the full new regime, including the technical standards that must be published by AMLA, are expected to be applicable as of early 2026. So this is promising. We'll see how the EU is able to cope with its intent to adopt things speedily, and well, we'll see how this evolves, and I'm sure we'll have an update discussion on this topic very soon. Thank you so much for your attention, and I'm obviously available should you have any questions.